Hey everyone, and welcome to the AI Tech channel. Today, we're diving headfirst into a legal battle that could reshape the entire AI landscape. It's a story of copyright, content creation, and the very future of generative AI. Are you ready for this? Because trust me, it's a wild ride. Imagine a world where everything you create online, your articles, your art, your music, is used without your permission to train AI models. Sounds like a nightmare, right? Well, that's exactly what's at the heart of the New York Times versus OpenAI lawsuit. And the latest twist? An AI maker was just found liable for copyright infringement. What does this mean for you, the content creator? And what does it mean for the AI companies building these powerful tools? Let's break it down. Okay, so here's the news. The New York Times is suing OpenAI, the creators of ChatGPT, for allegedly using their copyrighted articles to train its AI models without permission. This isn't just about a few articles. It's about the massive scale at which OpenAI scraped content from the internet, including the NYT's archives. The Times argues that this unauthorized use infringes on their copyright and has cost them significant revenue. They're seeking substantial damages and a court order to prevent OpenAI from using their content in the future. Now, OpenAI, like many other AI companies, has argued that this kind of data scraping is fair use. They claim that AI models learn from the data they're trained on, just like humans learn by reading and analyzing information. They say that restricting access to data would stifle innovation and prevent the development of beneficial AI technologies. But the NYT isn't buying it. They argue that OpenAI is profiting from their content without compensating them, and that this undermines the value of their journalism. They're not just fighting for themselves. They're fighting for all content creators who depend on copyright protection to make a living. This case is a major test of copyright law in the age of AI. The outcome could have huge implications for the entire industry, determining how AI models are trained and how content creators are compensated. This isn't just a legal squabble, it's a battle for the soul of the internet and the future of content creation. To understand the stakes, let's dive a little deeper into how these AI models work. We're talking about large language models, or LLMs. These models are trained on massive datasets of text and code, allowing them to generate human-like text, translate languages, write different kinds of creative content, and answer your questions in an informative way. Think of it like this. Imagine reading every book ever written, then being able to write your own stories in any style you choose. That's essentially what LLMs do. The key is, well, a lot of it comes from the internet, including copyrighted articles, books, and other content. This is where the legal battle begins. AI companies argue that they're using this data for transformative purposes to create new and innovative technologies. Copyright holders argue that their rights are being violated and that they deserve to be compensated for the use of their work. The truth is, there's no easy answer. The law is still catching up to the technology, and there's a lot of uncertainty about how copyright applies to AI training. One important concept here is fair use. Fair use allows for the limited use of copyrighted material without permission for purposes such as criticism, commentary, news reporting, teaching, scholarship, and research. But fair use is a complex and fact-specific doctrine, and it's not always clear whether AI training qualifies. For example, a paper published by the Stanford Law School, titled Fair Use for Artificial Intelligence Training, explores the nuances of this issue, arguing that certain types of AI training may be considered fair use, while others may not. The court will have to weigh the benefits of AI innovation against the rights of copyright holders. This is a delicate balancing act, and the outcome could have far-reaching consequences. Now, let's get into the nitty-gritty of the legal arguments. On one side, you have the New York Times, arguing that OpenAI's use of their content is a clear violation of copyright law. They point to instances where ChatGPT has reproduced verbatim excerpts from their articles, suggesting that the AI model has essentially memorized their work. They also argue that OpenAI is profiting from their content without permission, undermining their business model. Think about it. If people can just ask ChatGPT for the news instead of subscribing to the NYT, what incentive is there to pay for journalism? On the other side, you have OpenAI, arguing that their use of the NYT's content is transformative and falls under fair use. They claim that they're not simply reproducing the NYT's articles, they're using them to train an AI model that can generate new and original text. They argue that restricting access to data would stifle innovation and prevent the development of beneficial AI technologies. They might even argue that their AI is creating something new, a derivative work that transforms the original material. And, in fact, derivative works are another important aspect of copyright law. A derivative work is a work based on or derived from one or more already existing works. Copyright law gives the owner of the original work the exclusive right to prepare derivative works. Now, there's a way to verify if OpenAI is simply spitting out the same data it was trained on. You can try prompting ChatGPT with very specific questions or phrases that are known to appear in NYT articles. If the AI model consistently reproduces those phrases verbatim, it could be evidence of copyright infringement. Another approach is to analyze the AI's output for stylistic similarities to the NYT's writing. Does the AI use the same vocabulary, sentence structure, or tone as the NYT's journalists? If so, it could suggest that the AI is relying too heavily on the NYT's copyrighted material. The court will have to weigh all of this evidence to determine whether OpenAI's use of the NYT's content is fair use or copyright infringement. It's a complex and nuanced issue, and there's no easy answer. So, what does all of this mean for content creators like you and me? Well, the outcome of this case could have a profound impact on how we create and share content online. If the NYT wins, it could set a precedent that makes it much harder for AI companies to train their models on copyrighted material. This could lead to higher costs for AI development, slower innovation, and potentially less powerful AI tools. On the other hand, it could also lead to a more equitable system where content creators are fairly compensated for the use of their work. This could incentivize more people to create high-quality content, knowing that their rights will be protected. If OpenAI wins, it could embolden AI companies to continue scraping content from the internet without permission. This could lead to a further erosion of copyright protection and a decline in the value of content creation. It could also create a situation where a few powerful AI companies control access to information, potentially stifling creativity and innovation. The truth is, the future is uncertain. But one thing is clear. This case is a wake-up call for content creators. We need to be aware of our rights, and we need to advocate for policies that protect our work. We need to ensure that AI is developed in a way that respects copyright and promotes creativity. We need to have a voice in this conversation because the future of content creation is at stake. This isn't just about the New York Times. It's about every artist, writer, musician, and creator who depends on copyright to make a living. Your voice matters. Your content matters. And your rights matter. In conclusion, the New York Times versus OpenAI lawsuit is a landmark case that could reshape the future of AI. The outcome will determine how AI models are trained, how content creators are compensated, and how copyright law is interpreted in the digital age. The stakes are high, and the implications are far-reaching. Whether you're a content creator, an AI developer, or just someone who cares about the future of technology, this is a case you need to be following. We'll be keeping a close eye on this case, and we'll continue to provide you with updates and analysis as it unfolds. But we also want to hear from you. What do you think? Should AI companies be allowed to train their models on copyrighted material without permission? Or should content creators be fairly compensated for the use of their work? Let us know in the comments below. And don't forget to subscribe to the AI Tech channel for more in-depth coverage of the latest AI news and trends. Thanks for watching.